All right, we are live. Quick, I already put it in the chat, everybody, but starting a little bit early. Just quick disclaimer. I'm getting over a cold. Had 103 fever, feeling better. But if you don't want to hear coughing sounds in the stream, I recommend you don't watch the stream. I'll be better next week. But right now, I'm coughing a little bit. And I want to do a live stream because I know people kind of freak out if I don't do a live stream and they want their questions answered. So I want to do that for everybody. But like, heads up, I'm going to cough today. That's it. That's all I'm saying. Looks like we got one person in chat. We're warming up. It's 5 o'clock now. We were starting at 5, so we started a little bit early. Hopefully, we get some questions that we can answer. A little water. Hello, Nana. How you doing? Do you have a question that I can answer? Anybody got a question? Atlanta Brandon, how you doing? I visited your fine city like 3-4 years ago. I got a boy who got moved there by Lockheed. Good guy. He loves it. He loves Atlanta. He thinks it's the best place in the world, which kind of makes sense because he comes from Binghamton, New York. So big upgrade. Norma DePlume says, I'm an EEOC reconsideration, then I'm going to district court. Should I ask for a jury? Generally, yes. If you're dealing with workplace discrimination, Norma, or workplace sexual harassment, you would like a jury in most cases. Yeah. Listen, arbitration has its advantages. But, if you can get a jury, that's a big deal sometimes. Exec Monster X says, can you file a complaint against an opposing attorney with the ARDC? Can you file a complaint? Well, normally you follow the guidelines for filing a grievance against the attorney. Is that... So I would go with probably go with the bar association in your local area for filing a complaint. I don't know if the ARDC would accept a complaint against an attorney, but I would probably look at the bar association locally and see what their best options are for filing a claim against the attorney. YouTube user Pamaroon says, what is the scarlet letter for all attorneys in regards to ruining their career? Touching the escrow account or letting someone in your firm touch the escrow account. That's how that's how careers for attorneys are destroyed. If you murder someone, it will have less impact, and plead guilty to it. Get caught, plead guilty to murder, the whole 9 yards. It will have less impact, generally speaking, on your law license, your ability to practice law, than touching an escrow account. Just Pamaroon, that's the truest answer I can give you. Excuse me. Atlanta Brandon says, yes. How long should it take for a lawyer to write your case up and file in court after talks with the defense? Month, 2 max. Corey, hi Vince. If my case has moved cities with the EEOC to a new city, a new caseworker, what does that mean? Thanks again. It means the EEOC is busy. Pardon me, everybody. Cough is getting worse. Just means the EEOC is busy. They move cases around. Ramona Hudson says, I would love to know why my attorney only discussed my bottom line number. My mediation is November 14th. We haven't discussed what the case is actually worth. I've emailed her with no response. Well, your attorney's probably trying to figure out what ballpark you're in for settlement. If your bottom line is $30 million, there's probably not, in most cases, there's probably not too much reason to keep talking settlement, right? Maybe that's what she's trying to figure out. I don't know. The Trauma Center, a place for healing, says, Vince, this cough. I'm going to go short today, everybody. I'm just going to be upfront about it. This cough is killing me. Vince, we talked before about agency counsel having a conflict because involvement in discrimination. My question is, how do you address it to the bar complaint, etc.? So generally you would file a grievance with the bar association. That's one of the best ways. And the grievance process usually set out in your state's bar association website. Excuse me. Tiffany says, hi, Vince. How common is it for the employer beating through attrition on plaintiff's side? What do you mean? Who beating who through attrition? You mean by filing more claims? Do you mean by doing more discovery, filing more motions? Who's doing it, and what specifically do you mean? Because plaintiffs never win through attrition. Almost ever. Plaintiffs can try, but the average plaintiff's firm is going to have 1/100th the attorneys of the average defense firm in this field. So you can kind of do the math. A little bit of water here, try to get the cough under control. All right. Staka Khan says, great username. Previous job won't cooperate with arranging witness interviews for the EEOC investigation, but job emailed me back to talk about my concerns. Well, sounds like you might end up getting a right to sue letter and going on to federal court. I think there's it's an entirely possible outcome here if they're not going to work with the investigation. We need more questions. We have 16 people concurrently. Only 4 people have liked the stream. If you could, it does help the stream to be seen. So it's awesome if you like the stream. Corey says, if I don't take the right to sue letter, does that mean the EEOC will represent me if I don't have a lawyer? No. I think it's less than like 4% of the cases the EEOC brings. Will the EEOC represent the person, Corey? It's incredibly rare. Norma DePlume says, also, Corey, just for the record, you don't get to choose whether you get the right to sue letter or not. Like, they're going to give it to you. You can use it or not, but they're going to issue it, generally speaking, in most cases. Norma DePlume says, my employer's attorney gave me 100 interrogatories. It's not a murder trial, so unprotected, it was a continuation of harassment. Am I wrong? No, 100 interrogatories is not harassment. That's standard. That's not shocking. Stakakan says, thanks. You are very welcome. Ramona Hudson said, is she going to wait until the week of, you think? I don't know. Ramona, I don't know what your attorney's thinking. Norma DePlume says, I protested. 100 interrogatories? Doesn't seem unreasonable to me, Norma. Mohammed Irfan says, if employer doesn't give the Social Security number benefits in W-2 to employees, can employees sue the employer? You can report them. I don't know if there's a private right of action for not issuing the W-2. There might be, but you can also report them much easier to the federal and state taxation authorities very easily, and they get in a lot of trouble. The Trauma Center, a place for healing, says, are there any tips for coming to earlier resolution with federal employers? It seems they wait until after the summary judgment. Yeah, federal employers make things hard all the time. It's not their money, so they don't really care. And there's not a lot of consequences for them if the EEOC finds against them, Norma. Or not Norma, I apologize, Trauma Center. So, like, I don't have a method for pushing federal cases faster besides try to make individuals with power look bad, because they're the ones who, if they start looking bad in the case, can actually effectuate some kind of change for you and start pushing for deals. Okay. Excuse me. Atlanta Brandon says, is asking for $365,000 in a retaliation case high? And question 2. So right off the bat, Atlanta Brandon, I don't know if that's high because I don't know anything about your case. I would tell you to hit up the damages calculation playlist because every case is different. And in your retaliation claim, you're going to have punitive damages, and that's very speculative. So it's hard to get cases settled on punitive damages, but you might have other damages as well. So there's a lot going on there. I would hit up the damages calculation playlist. To get to the second part of your question, does dealing with a lawsuit and the lawyer get the check first? Can my lawyer take my taxes out for me before I get my check? No. I don't think your lawyer can handle your taxes for you. Listen, I can't give you tax advice, and I'm not a tax attorney, but I don't know that there's a way for your lawyer to handle the taxes for you. I guess you could ask them to set aside money for you for taxes. It's an option. Ramona Hudson says, I don't know what to ask for. I only have a couple of weeks. Excuse me. Ramona, you got to hit up the damages calculation playlist. It's going to walk you through all the complexities of calculating your damages. I'm concerned that your attorney's not doing that with you and for you. But if she is not, then you should hit up that playlist for sure. John Doe KCK says, hey, Vince, I hope all is well. Thank you, John Doe. Coughing like a fool, but I'm doing my best. Thanks as always for the content. Oh, and Elgato Stream Deck is your friend to set up a mute when you cough button. I need a mute button desperately right now. I'm so sorry for the coughing, everyone. The more I talk, the more I cough. But I wanted to get people answers. And I don't think people care about the quality of my audio. I think people just want answers, right? So I'm hoping. Corey says, how long does the company have to respond to the rebuttal from the position statement? Can you explain the steps leading to this getting settled? Generally, they get about 60 days in my experience, but they can get multiple extensions, Corey. In terms of settlement is very simple. Somebody makes a demand. There's a conversation. There's a negotiation. You might arrive at a deal. Boom, case is settled. Luna Dietz says, my case is heading towards arbitration. I'm worried. Does that mean I'll lose my case? No, arbitration can be great. Listen, not all arbitration is bad. I work as an employment arbitrator, and I'll be upfront. I don't take cases that are mandatory arbitration where people where the employees specifically didn't get an option about being in arbitration. But that being said, I have a lot of clients that I specifically put in arbitration because it benefits them in one way or another. Arbitrators are not unfair necessarily, right? Like, when I come to an employment case, I'm not like looking to screw somebody over. I'm looking to hear the case and decide the case fairly, right? Like, it's not, I have no interest in harming anyone. My only real interest is like listening and making a fair decision. So I don't think arbitration is horrible. Luna, I don't think it means you lose your case. That's for sure. Kelsey says, does discovery normally get extended in a workplace discrimination retaliation case? Yes, almost always. There's going to be huge fights about what gets turned over, what doesn't get turned over. There's going to be delays. The defense is going to delay things. Plaintiff side might even delay things. Depositions might take a long time to schedule. There's almost always going to be extensions in discovery in these cases. Norma de Plume says, I am federal. Got it. But I'm not sure my bosses have any power over an attorney employed by higher up federal department. My bosses are terrified. It's possible, certainly. Ramona Hudson says, I'm so sorry about the coughing. I've done the calculation playlist. So the damages calculation playlist, I presume. It says 200 to 300,000. Is this high for sexual harassment and disability discrimination? No, not at all. I would actually say that might even be low. Thank you so much for Ramona said, you're helping us for free. Cough if you need to, Vince. Thank you very much, Ramona. I really appreciate you understanding. John Doe KCK says, don't be sorry, man. A cough or two doesn't matter. As you said, people just need the information you provide. That was the logic, right? Like I was like, I've been absentee for almost a full week. I got last Thursday. I had 103 fever, felt like garbage. Couldn't make videos, coughing too hard, low-key delirious. And I felt bad. So I went a week without making videos. I started putting videos up again. John Doe, I don't know if it was the Rona. I also don't know if I can say that on YouTube without getting demonetized. So there we go. Luna Dietz says, why would my attorney tell me it's going into arbitration? Is there no option for non-worker comp, non-subscribers in Texas? Luna, I assume your attorney is telling you it's going to arbitration because you are subject to an arbitration agreement of some kind. I could be wrong, but if you sign an arbitration agreement, that might be why your attorney is telling you your case has to go to arbitration. Most attorneys would not opt to put a case into arbitration except in special circumstances, right? Like if I have famous clients or clients that are really high earners, sometimes I put them in arbitration because the arbitration is confidential and can be used to keep things quiet. So, a famous person or a person who's going to have a really valuable career and doesn't want future employers to know about their case might want to be in arbitration. That's another reason. But Luna, I suspect the reason why is simply that you're subject to an arbitration agreement. Lucky 7 says, do you think it's a good idea to request a right to sue letter and go forward on your own? No, if you're representing yourself, not at all. I don't want to be in investigation for years with this. Excuse me, with this. And from my perspective, I've noticed the EEOC is trash. Yes. Lucky 7, agree with you about the EEOC. Here's the problem. Litigating one of these cases in federal court without an attorney, just pro se litigation, is an act of self-harm. Like the success rate is so incredibly low. And people on this channel, people who watch this channel have succeeded and won sizable verdicts pro se. It can happen. It can happen. I'm not going to say it can't happen. 999 out of 1,000 people who litigate pro se are just harming themselves. And that's the reality. You can win. It can be done. But it's incredibly difficult. And that's just my 2 cents. Tammy Hoffman says, if I filed an internal complaint and then got suspended and was on medical leave and then went back to work and wasn't able to clock in and work for 5 hours off the clock, that's illegal, isn't it? For plus today, that's illegal. Plus today was payday, and they never even paid me for the 5 hours that I was even there. So Tammy, yeah, if they fired you because you made an internal complaint of like workplace discrimination, workplace sexual harassment, unpaid wages, safety, something like that, it's entirely possible that you have a claim. It's also possible if you think they took you off, they limited your ability to clock in because you were on medical leave, like you had a disability you need accommodations for. That's something. But did you notify them that you were coming back? Did you like have a conversation with them? Because if you worked without telling them you were coming back, that could be an issue. That's a confusion, but you do have to be paid for the hours you work, certainly, especially if they let you work. Luna Deet says, I'm supposed to be in my wheelchair. I live on the 3rd floor. I'm worried about private investigators. I'm worried they'll dismiss my case for going down the stairs. Can't help you with that, Luna. Yeah, that's a little outside my realm of I don't do disability benefits, which is, I think, what you're describing. I do disability discrimination. IP Blackman Jr. says, how long does the employer have to answer EEOC charge? Usually about 60 days. Norma, but they can get extensions. Norma DePlume says, I'm learning from you and all these questions, and I'll be sharing with other federal employees. So I appreciate your time here. My pleasure, Norma. Happy to help. Louis Rivas says, question, does your employer type full-time or part-time matter in employment cases? And the company profile matters in pursuing a case. No. So whether you're full-time or part-time does not change your legal rights vis-a-vis being free from discrimination and sexual harassment in the workplace, but it can change your damages calculation. YouTube user Corey says, so what would be the next step after they respond to my rebuttal? What's the next step if we agree to mediation, but the company sent a position statement in response to mediation? So if the company did not agree to mediation, then you are not getting the EEOC mediation program. And your next step would be to talk to your attorney about potentially going on to federal court. Cuppy J says, my attorney filed lawsuit and I'm still employed. Can I refuse for internal investigation related to the claim? Well, if you're represented by counsel, you would just say like, hey, I actually have an attorney. My attorney's handling this, and kind of just have your attorney lean on them that way, so you don't have to do the internal investigation. Yeah, HR is just trying to harm you, so I would absolutely do that. NYC Damages said, if you are in the EEOC, dual filed, and another incident happens, can you file with the State Division of Human Rights, dual file with the EEOC to get their discovery process possibly faster than the EEOC? Yes, you can file a new case, certainly. IP Blackman Jr. says, employee dies after supervisor denied employee to leave to seek medical attention. Will this situation help my EEOC charge versus the employer? Well, it depends on what you're alleging. Certainly that does kind of make the employer look bad. But I mean, it depends on what you're alleging as to whether or not that would be useful evidence. Ramona Hudson says, can I get the 200 to 300,000 in mediation? Is this heard of? Ramona, I have settled cases for 200 and 300 and 500 and 600 and I think 800, 900,000 in mediation. Generally, if you want, that can happen. Certainly. No question. I don't know if that's legitimate in your case. I don't know your case, but it certainly happens. And Landon Brandon says, let's get the likes up for Mr. V. He's giving us free game to our problems. Thank you, Brandon. I appreciate that. We got 31 people and 22 likes. That's a pretty good ratio. I appreciate that. Anish says, if my case is 2 years out, will the judge lose interest because the incident was 2 years prior? No, not at all. Linda Hawley says, hi there. Have you ever heard of implicit bias in the interview process? Yes. Working on a prima facie case, sexual orientation discrimination, failure to promote. My employer doesn't score answers. Oh, okay. Yep. Listen, implicit bias is real. It lives in all of us. It's reality, and it certainly can be litigated. AR American, I hope you're well. Will Anderson says, can a private investigator help to get statements from coworkers before the memories fade while I'm working to secure representation for a disability discrimination case? They can, although in an ideal world, your attorney would coordinate with that PI instead of you. Eric Rose says, hi. Hi, Eric. Miss Tiff Tigress says, happy Friday, everyone. Happy Friday, Miss Tiff Tigress. Lucky Seven says, let's say we're granted free therapy from a nonprofit organization with a licensed therapist, of course. Does this change the amount of your monetary compensation for emotional distress? No. As long as you will be able to find that therapist later and have them testify, then that is perfectly good for my purposes. NYC damages. Why for the initial claim with the EEOC is it a short version of the claim as opposed to a full detailed claim with exhibits proving it like a lawsuit? Wouldn't that speed up the EEOC process? NYC damages, I can't tell you why the EEOC does anything. Frankly, they're silly. I will say that the way that pro se litigants file their EEOC charges is very different from the way attorneys file the EEOC charges. We have long form narratives for our EEOC filings, and the EEOC loves them. And we seek to do the EEOC's work. Often we do attach exhibits, at least, especially in rebuttals, but also even in original filings. So what they give you to fill out is not what we submit. Not even close. Atlanta Brandon says, does it look bad for a company not to respond back to a demand letter? Not really. They just might not want to settle, and so they would not respond. Anish says, can you get a trial moved up? Is it a thing? Sometimes. It can happen in certain circumstances. The Trauma Center, a place for healing, says, what should you do if the employer only investigates 3 of 7 claims and issues a right to a hearing and notice of impending FAD on mixed portion? I do have another case approaching hearing. Well, Trauma Center, a place for healing, I would not file in a way that leaves your employer in the position of power to decide what cases get a hearing and what cases don't. I would file with an agency that has outside power. Luna Dietz, thank you for your help. I love watching your videos. They are very helpful. Luna, I hope they are helpful. That makes me happy. Ted Hyman says, I think people are losing faith in the court system. Yeah, that's probably fair. I mean, I don't know how much faith people really had to begin with, in all honesty. JB says, is there any leverage in contacting Congress if your 3-letter federal law enforcement agency is dragging out the EEOC investigation process? I don't know, JB. I don't know. So, like, most of the time when people write to their congressperson, I think it's useless. But I will say for federal employees, once or twice, I have seen it make a difference. So it's possible. IP Blockman Jr. says, does employee dying on the job due to the supervisor denied employee medical attention, does this qualify as discrimination? No. So discrimination is a negative workplace consequence motivated by membership in a protected class. So an employee dying on the job, if it's motivated by some kind of aggression tied to a protected class, could be tied to discrimination. But in and of itself, it's not necessarily discrimination. It could just be they're greedy or horrible or incompetent or any number of other things, right? Or just an accident. Natural Intellectual says, do companies ever review incriminating evidence and just settle? Absolutely. I would say almost about 15% of our cases settle in the first 3 months. And almost all of those cases are cases where the employer just looks at what we show them and says, oh yeah, okay. How many zeros on the check do we think? What's going to get this done, right? And then you have a negotiation. Freya says, do you know of any great sample EEOC complaints online? I haven't found one yet. I do not. I'm sorry. Freya, I would say just write your narrative. It's the most important thing. Put your story in time order and really show anything, talk about anything that shows that you were discriminated against and all the negative workplace consequences that you experienced in time order. Ramona Hudson says, how are funds for mediation dispersed? Ramona, if you settle your case at mediation, depending on the jurisdiction, you're going to have to wait usually about 4 weeks, but it changes jurisdiction to jurisdiction. The checks are usually going to go to the attorney for you, and the attorney will give you your share. The Trauma Center, A Place for Healing, says, could you expand on the agencies that would have that outside power? So it depends where you are, but I mean, if I recall correctly, you might be in New York. So New York City Commission of Human Rights, the New York State Division of Human Rights, EEOC has the power to issue your right to sue letter. You can file in state court, federal court, lots of options. A little bit of water. Okay. Lucky 7 says, is it a good sign if you found on Pacer 3 prior claims against your employer for 3 different charges? Looks like there's been settlements in all 3. Does it appear the company never wants to go to hearings? That is positive. Listen, if they have a tendency to settle, that's great for you. I like that. Norman de Plume says, what besides money are good settlement items? Training, promotion, relocation, housing in a new city. I don't know what I don't know. So you can ask for anything you want, Norma. I would say that it's not a legal question, right? So the things you want, you can ask for anything legal in a settlement agreement. Doesn't mean they're going to give it to you, but if you want it, you can ask for it. If you want a promotion, you want relocation, ask. They might say yes. Okay. IP Blackman Jr. says, can I contact you directly? No. You can contact our intake department and they'll talk about potentially taking your case, but you cannot contact me directly. I'm sorry. The call volume of people trying to contact me directly is way too high. I'm not trying to be an asshole about this. I have clients. I talk to potential clients. I do this. At this point, if I was taking like everybody who just wanted to talk to me about their case, like for helpsies, it would legitimately be like over 4 or 5 hours a day. It's a lot of volume, and I apologize. I can't do it. I can't afford to. I gotta keep this firm going. We gotta help our clients. It is what it is. Natural Intellectual, thank you for your charity. Oh, thank you. Your charity does not go unnoticed. May God bless you. Oh, it's very kind of you, Natural Intellectual. It's very kind. Thank you. Ramona Hudson says, is the reason why we can't get a real settlement numbers the disclosure agreement? So it's the confidentiality portion, right? The NDA, the non-disclosure agreement. Happy to help, Trauma Center. Estify says, great username. When I've been with a firm for 9 months, it's finally moving along. What happens if it goes to the state attorney's office? I was told I need to talk to an investigator. What are the next steps? Depends on which state you're in and what jurisdiction you're in. Estify, I can't say necessarily. Different from state to state. Generally, we deal with federal claims here, EEOC, and then federal court. NYC Damages, EEOC does initial interviews, and then they write the initial compact filing. Are you saying when you file with your office that the attorney joins the initial EEOC interview? I'm actually going further than that, NYC Damages. There is no initial EEOC interview when our firm handles the filing. We file a narrative, which is a sworn statement, which means that the initial interview is not required. There will be a conversation with the investigator that comes later during the fact-finding conference stage, but There is no initial interview. We take care of it, and we submit a preset narrative events that we have tweaked to make it the most effective retelling of those events possible. And we do not expose our client to being questioned, because the more times you tell your story as a plaintiff in this field, the more chances you have to say something different, and that is not ideal. And I'm not saying our clients are lying. When humans tell stories, there's always a little bit of variation, and people try to spin that variation into an inaccuracy to make the plaintiff look bad. And I don't care for that. It's not how human beings tell stories. It's a ridiculous tactic, but sometimes it can work if you let it. So you have to be careful. Copy J, can I send non-sensitive email to my personal email to pertain key evidence to my case? Would it be a problem if the company finds out they don't contain any confidential or sensitive information at all? Copy J, if you're not subject to an agreement not to do that, then that might be fine. Check with local counsel, check with the local laws of your jurisdiction. Many employers have rules about that, and you have to comply with those rules. AR American says, thank you, Vince. Hope you are also doing well. Any advice on gaining favor with a judge with a status hearing weeks away? Get all your stuff done. Be timely. Be respectful. Wear a snazzy suit. Smile. Judge will love you. That's all you can do. John Doe KCK says, when opposing counsel drags things out longer than necessary, do you or your firm have a tendency to increase the settlement amount? No. That you're trying to get the defendant to cut a check for? No. But conversely, the longer you're unemployed, if hypothetically you're unemployed, your damages do grow, right? So we don't increase the settlement amount, the settlement demand, or the damage calculation for that matter, because the other side is going slow. But as time passes, that can increase the damage calculation and then the settlement amount as a result. NYC damages, when you say, I don't know why the EEOC does anything, it really helps us staying sane in this insane process. Thank you so much for doing this for anyone who will see any of your videos. My pleasure, NYC damages. I hope it helps in some way. It feels silly to do this, to talk into a camera like this. I don't know if you do this, but it's like a weird thing to do because I'm alone, right? Like there's no one here. So it's just making these videos, just me ranting at a camera feels weird. So I'm glad it helps. It makes me feel better that it helps somebody. Kelsey says, do federal judges really have the time to review all details of a case and its minutia when making a summary judgment in an employment discrimination case? Kelsey, so federal judges have staff attorneys, and those staff attorneys will review things like summary judgment motions and make recommendations and provide summaries and provide well-reasoned memos for the judge to aid in the judge's decision to be more efficient in that process. I'm not saying the judge isn't going to read the papers, because I think it could get me in trouble if I did say that. I would never allege that judges aren't reading the motions that they're deciding, but I've certainly heard it alleged. But I wouldn't say that. But I've heard it. Heather's opinion. Are arbitration awards public record? Depends on the arbitration. Also on the jurisdiction in some situations. Tom Doherty says, had my initial investigation with the Massachusetts Commission Against Discrimination. It was very short. They asked me, I think, 2 to 3 questions only. I'm a white man filing discrimination. Bad sign. I don't know, Tom. I don't know what you... I don't know what your protected classes were. I don't know what kind of discrimination you experienced or sexual harassment you experienced. Maybe the case is very clear cut and they don't feel they have to ask questions. Maybe it's a great sign, but I can't extrapolate from that information. I'm sorry. Whoa, chat jumped ahead on me. YouTube user JB says, in this case, the ATF paid out $450,000 in settlement. Cheryl Bishop v. Merrick Garland et al. I've been told the max is $300K in federal EEOC process. Is there a loophole? So you might have additional claims, JB. You might have I would have to look into that case. But there's certainly ways to get more. Normally, the way people get more, and this is not true for federal employees. I assume this was an ATF employee. And listen, ATF kills more dogs than it saves people, but not one of my favorite federal agencies. INS and the ATF. Not my favorite. A lot of times for private employees, the caps are kind of meaningless because they're going to have state law claims and local law claims that are not subject to the same caps. So it's not really an issue. I would have to look at the Cheryl Bishop v. Merrick Garland et al. Case to ascertain as to how it beat the caps, but I would suspect it's just multiple claims. The Trauma Center, a place for healing, says, given the delay game federal agencies take in the hearing process, or federal court route the faster? I think federal court's much faster. Lucky 7 says, when doing your rebuttal to employer's position statement, do you upload all evidence or leave some for the suspense factor? Like, bam, you guys didn't think I had this, did you? Or only crucial evidence? So, Lucky 7, I would say hit up our rebuttal writing 101. But if you're looking to wrap things up at the EEOC stage, I would use your best evidence in the rebuttal. If you're looking to go on a federal court, don't do a rebuttal at all. AR American says, I know punitive damages are hard and rare to win. What's needed to acquire those damages? So it depends on what you're seeking punitive damages for. We have a lot of videos on punitive damages tied to retaliation claims in this field, right? So if you oppose discrimination, or you complain of discrimination, or you oppose sexual harassment, or you complain of sexual harassment, and then something negative happens to you, there's a presumption that that negative thing that happened to you could be retaliatory. That can very easily give rise to punitive damages. Now, punitive damages are speculative, so you often can't get them in settlement, right? That can be an issue because defense counsel will say, well, we don't know how much you're going to win, so we can't really negotiate based on that, right? It's an argument. I don't think it's the best argument, but it's an argument, and they often make it. Now, what I always say is, that's fine. You can argue that it's speculative, but you're facing down the barrel of a sizable verdict here. So this punitive damages thing could really get out of hand on you. And you're over here telling me you want to pay 60 cents on the dollar for my claims, but it seems like you're ignoring the fact that I got this big punitive damages thing that might happen, might hit you like a train, like a bus, if I go to trial. So I don't think you really want me to go to trial. So you're at 60 cents on the dollar trying to settle my claims with my client. And I think you're not valuing those punitive damages and how scary those could be for your client. So maybe we should be talking about 80 cents on the dollar, right? It's a source of leverage, even if you don't capture the value. But generally, you are going to have to go to trial and win that retaliation claim in this field if you do want the punitive damages. And Rodriguez says, can I ask for the employer position statement prior to mediation in Texas? At the EEOC level, no. Based on my experience, you cannot, because the EEOC holds mediation before they take a position statement. I can't say as to the Texas state agencies. I don't know. Nor could I tell you if I did. Freya, at what point do discovery demands occur in the timeline of an EEOC complaint? Most EEOCs do not have extensive discovery, but you can, during the fact-finding conference, request that the investigators seek certain items, make demands for certain items. You can also, in certain situations, go further than that, but that's generally during the fact-finding. Ramona Hudson, should I be nervous about the upcoming mediation? Not at all. You should watch our mediation preparation playlist. It's going to get you comfortable. I've seen a lot of demonstration online, but reality bites. Now, listen, Ramona, it's people getting together to talk about giving you money. That's all it is. Like, it's going to be hard. It's going to be emotionally difficult. You're going to have to make tough choices. It's not going to be fun, but it is still, at the end of the day, people getting together to recognize that you have a claim and they want to cut you a check so that that claim doesn't go forward. Not the worst day, right? Michelle Cephas says, glad to see and hear you are okay. When I noticed you were not posting anything, I was very concerned. Michelle, I apologize. I had a bit of a fever last week. I had quite a cough. It is a little bit better now. as long as I keep drinking my water. And I am back to making videos. YouTube user Aristotle Rush says, are constant amendments or constantly having to amend things in the beginning of a lawsuit normal? No, it's rare to have more than one amendment to a complaint. That I would wonder what's going on if there was multiple amendments to a complaint that was been filed. AR American says, so I asked my paralegal if I needed to be at the status hearing. I was told I don't need to be present since it's just the status hearing. Only attorneys. Is that how certain hearings are handled? Yeah, so it's not a status hearing. It's a status conference, I suspect. AR American. And they're just setting a schedule. You don't have to go. You can go. It's your right to go. It's your case. You can be there if you want to be there. And if you have some kind of level of discomfort with your attorney, or you want to gain like a confidence in your attorney, it doesn't hurt to go. But yeah, generally just attorneys go. Status conferences. You don't need to go at all. NYC Damages says, yeah, and government workers could hear different things than you say, not limited to the EEOC. LOL. Absolutely. Big Z says, hey, Vince, I just received my employer's position statement after 7 months. They lied and intentionally left out pertinent info about my claims. Any specific strategy you recommend for the rebuttal? Yeah. We got a video here on the channel called Rebuttal Writing 101. It's pretty extensive. It's got most of my thoughts on rebuttals. It is a simplified version of rebuttals. It's not how we necessarily do rebuttals, but it is an effective means of putting together a rebuttal that I used early in my career. It's not what we do anymore, but it is what I did early in my career for people, and it was very effective. So I would definitely hit up that video, Rebuttal Writing 101. And I hope you get paid, Big Z. Jaquan Brown says, hey, I work for a moving company, and recently my job has refused to give me any hours, going on for about 2 weeks. They will not fire me, and every time I reach out to my management, I get no response at all. Jaquan, I would argue that you may have been constructively terminated, and you could potentially apply for unemployment benefits because they've given you no hours for 2 weeks. But check with local counsel to confirm that that is true in your jurisdiction. Excuse me. YouTube user Clevy26 says, what happened after a failed mediation? The employers have to submit a position statement. If yes, how long will they have to submit this? So they don't have to submit a position statement. Technically, there's not a lot that happens if they don't. However, most employers want to because it's better for their case, right? So after the mediation, case gets moved over to enforcement. They get time to put together a position statement. If they submit the position statement, you put together a rebuttal if you want to. EEOC pretends to investigate. Maybe there's further settlement discussions, and then a right to sue letter is issued. AR American says, should I insist on being present for a status conference? I wouldn't, unless you're uncomfortable with your attorney. If you're uncomfortable with your attorney, go watch your attorney. Make sure you're comfortable, right? But if you're comfortable with your attorney, no, you're good. No need to go. Let's get a bit of water. We got 17 minutes to go. Okay. Jeremiah McKinnis says, during an otherwise confusing period, you've been the only constant I could reply upon. You've been super helpful. Jeremiah, that's amazing. Thank you for saying that. I really hope that's true. That's true, NYC Damages. I'm not alone on lives. Cuppy J, you're very welcome. Superficial Look says, are punitive damages only awarded if the case goes to court? Yes. Generally speaking, if you have punitive damages tied to retaliation for workplace sexual harassment or workplace discrimination, it is generally only going to be awarded if you go to a verdict at a hearing or a trial. Excuse me. Excuse me again. I apologize. Norman de Plume says, is pecuniary punitive? Does postal attorney just play with words? I'm sorry, Norma. I don't understand that question. Christopher Charles, if you're discriminated against and quit because of it, do you lose the right to sue? No, you do not. Christopher, you can make First and foremost, you can make constructive termination argument saying that things were so bad that you had to quit. And that can win in many cases. That's certainly viable. The other thing is the discrimination you experienced while you're employed is still something you can recover for. Just because you resigned, even if the court found that there was no constructive termination, you still experienced discrimination while you're employed. So there's still damages for that you experienced while you're employed. Aristotle Rush says, I'm losing it, people. This cough is getting me. Aristotle Rush says, are text messages and voice recordings in a one-party state great examples of direct evidence to prove your retaliation discrimination case? Certainly can be. Yeah, can be great evidence. Can be fantastic evidence. We got a fresh cough drop. All right. Whoa. All right. 15 minutes to go. Let's see. The Trauma Center, a place for healing, says, I have heard of individuals claiming discrimination in the agency handling EEO cases dealing with things like settlement. With most ending in settlement, how could you get information like this? What kind of information are you trying to get? Oh, I see. So you got to go look for verdicts. You got to look for verdicts. That's the only way you're going to find information. You could also see what you can find with a FOIA request with the EEOC. Might be an option. John Doe KCK says, how fast or slow relative to the non-existent average case is 6 months from sending the EEOC the initial complaint to them, formally asking the employer for a position statement? That is slightly slow, but not terrible by EEOC standards. Superficial Look says, if retaliation and discrimination is captured on video, Texas, should I submit all videos to the EEOC or save for later, like a smoking gun win? So it depends. If you think you're going to go on to federal litigation later, you might want to hold them back. If you want a settlement at the EEOC level, then you might want to go ahead and submit those videos right away. You could also submit some of the videos and hold some back. NYC Damages says, if you first file with the EEOC within 180 days, is there any deadline to rewrite or amend your initial claim? So individual investigators might tell you that there is, but fundamentally they have to take whatever you give them. So no, you can amend. Corey says, so mediation is out the window once a position statement is sent. Corey, EEOC provided mediation is probably out the window once the position statement is sent. However, there's nothing stopping you and the other party from having a private mediator. You can hire a private mediator. Also, if your case escalates beyond the EEOC, most federal court systems have a mandatory mediation program or allow for voluntary mediation. And at any point, you can have your own private mediator. There's no issue with that. Whoa, chat jumping ahead on me. NYC Damages says, and if you change your attorney after filing, can the new attorney amend the initial complaint with the EEOC? Yes, they can. Raraj Jewel 69 says, is it harder or possible to replace present representation with new representation when you're 10 days near the deadline of the statute of limitations for disability discrimination case? Well, listen, I would get something filed and then look at potentially changing representation. If you don't think you can trust your current counsel to get something filed on time, that's a big concern. You got to bring the new attorney and get that done right away. The only difficulty really with the deadline is you got to get the case filed by the deadline. There's not going to, in most cases, be a situation where they give you more time because you got a new attorney. C-Note 1906, Vince, thanks again for all you do. My pleasure. I am being deposed by defendant counsel this Monday. How exciting. I have a good prep with my attorneys. I feel pretty good. Any advice to give me? Gotchas, tricks? We have some deposition videos. I'd probably hit those up. Just stay calm. Stay calm. And when you hear a question, think about the answer for like a 5 count, because this will, 1, help you to give a better answer, but 2, give your attorney time to object if you're in a venue where you're allowed to object. YouTube user GB says, hi, Vince. Hi, GB. AJ SoFly69 says, hey, Vince, I was wondering how long the EEOC has technically after receiving a rebuttal to finish the investigation. I don't know. I've seen them go years, literally years. GB, I am feeling a little bit better. I actually feel fine. I just still have the cough, so I've been coughing on the stream, and I feel weird about that. But I want to answer questions, so I did my best, right? YouTube user Big C says, my employer stated in their position statement that I was fired for misconduct. Sounds like a pretext. But when I filed for unemployment, they said there was no finding of misconduct. Can I use that document in my rebuttal? Yeah, potentially. You might want to get the transcript too. YouTube user Kelsey says, what's your opinion on the moral character of defense attorneys to defend bullies and discriminators? Kelsey, I don't fully buy into that. So I understand what you're saying. And that is an easy thing to say. But I will say that everyone deserves representation, right? Like the worst murderer deserves to have representation. And so too does a sexual harasser or a workplace discriminator, because sometimes they are innocent. Or listen, a lot of times they're partially guilty. And part of defense counsel's job is to hash out like, well, how guilty are they? How bad was it? What did they do? And realistically, defense attorneys exist to cut my clients' checks. Overwhelmingly, right? In a field with a settlement rate north of 98%, they're out there in some ways fighting for you, right? Like, I know they're not. They're trying to chisel you down, make sure you take a smaller settlement. They're all these things, right? But they are the ones going to their client and being like, you moron, you need to cut this person a check, right? Like, you messed up. This is going to go badly for you. Like, so like, don't sleep on defense attorneys' role in that, right? And listen, I had someone who worked for me. She was an amazing attorney. She had a history as a rape counselor and came to the field like to fight for women. And she ended up going to defense side, sitting at the table with the sexual harassers. And I can remember the day she left, she was like, you don't think they're going to make me defend like people who like perpetrate workplace sexual assault? And I was like, yeah, I think that's specifically what they hired you for. Like they need you to sit at the table, young, respectfully attractive woman, as like social credit for this guy, these bad guys who do these bad things. And it was hard for her. It was a hard decision for her. You could see it because it was a lot of money. She made good money with us, but our money, you have to win your money with us, right? Like you gotta go out and rip that money out of a defendant. And if you go defense side, they'll guarantee you that $500K a year, sometimes. So, that's a reality. Sometimes you got a family, sometimes you got things you got to pay for, just got student loans, right? Like, listen, I know a lot of attorneys in this field subject to 300, 350, 400,000 in student loans. That's scary. How are you going to get out from under that, right? So I don't fault people for going defense side that much. I should not have said that much there. I don't fault people for going defense side. Nico Gomez says, is it normal for a paralegal to not know about every case the lawyer knows about? Is it normal for a paralegal to not know about every case the lawyer knows about? Yes. Yeah, I think that's perfectly normal. NYC Damages, one now former employee of the same company recently settled out of court on an EEOC discrimination claim. Same claim, different details. I don't know the details, just they got some money. Can this help in any way? Well, not yet in court to subpoena them. Well, listen, the employer wants to settle potentially. Ramona Hudson says, honey, lemon, and peppermint tea events. I am on it, Ramona. Thank you. GB says, is each request for accommodation a separate act of discrimination? For example, I made 4 requests and they denied the first 2 and ignored the third, but provided accommodations on the 4th. Yeah, those first 3 could potentially be actionable. AR American says, thank you. Sounds great. Feel very good about this now. I will just step aside then. I lowered my demand. Will that help in possibly getting a mediation soon? It might. Yeah. If you have a lower demand, certainly the other side might be more inclined to agree to mediation. GB says, they use the same medical documentation I submitted on the first to approve the fourth. Yeah, GB, listen, those first three might be actionable. I don't know what the damages would be because it sounds like they did ultimately accommodate you, but there could be damages there, certainly. 6 minutes to go. 6 minutes to go. What do we got? What do we got? All right. No new questions. 6 minutes to go. Lucky 7. When you've been denied unemployment based on the employer's lies, what if you win settlement? You're awarded back pay, front pay. Do you still get the unemployment benefits or the settlement cancels that out? Settlement cancels that out. Sorry. Same Madden says, will social media post about retaliation affect my claim? Zay, we got a bunch of videos about social media posts on the channel. I would hit those up. Posting on social media can be detrimental to your case. Certainly, it's not always, but it can be. It's a risk. It's a real risk. All right. Norman DePlume says, can or can't I use previous EEOC settlements with the same boss from various victims as evidence? He's a serial harasser, and I haven't addressed this yet. Potentially. Especially sworn statements from those cases might be particularly useful. HR employee was fired the same day I was. Well, that made my case a lot stronger. I don't know. Maybe. It could. It depends on the context. Medicated Bob says, I might have a tough one. All right, Bob, where's the question? Let's go for the tough one. Where's Medicated Bob? That's it. That's all you said, Bob. I might have a tough one. Medicated Bob. Got to ask the question or I can't try to answer it. Excuse me. Air American says, also, a supervisor quit. A GM was fired. Another HR employee was fired prior to the other one I mentioned. I have a very strong case, right, Vince? I have no idea. Depends on the context. They are American. All those people being fired could be great for you. I don't know. Candy says, hi, Vince. So my attorney sent a demand letter to my employer's attorney. I still work there. The CEO called yelling and threatening me about my claim. Is this retaliation? Yes, absolutely. It's an attempt to intimidate you. No question. AJ So Fly says, the person that took my complaint at the EEOC was very cool and said I most definitely have a case. Once we got to the investigation stage, I had someone else, then I was switched back to the guy that did the complaint. He's very much on my side. Is that a good thing? Yeah, it's good. It's great that that person commiserates with you and thinks you have a strong claim. KDTTV says, how should I prepare my rebuttal letter? KDTTV, you should hit up our rebuttal writing 101 video on the channel. It lays out all my thoughts on how you should lay out your rebuttal letter. Amen King says, my employer lied and told unemployment I was fired because of lack of work once they received the lawsuit. They changed it and said time and attendance. Can that help my retaliation case? Yes, absolutely. It shows that they are, one, dishonest, and two, they were full of it when they terminated you. KDTTV says, the investigator has just got back to me with the job site's rebuttal letter. Just curious on how to respond. Still rebuttal writing 101 video. That's the best thing I can give you. Hit up our channel, rebuttal writing 101. It is like a 20-minute video, I think, setting out how I think you should do your rebuttal. Corey says, HR up and quit once the company was notified of the discrimination case. Does that seem fishy? I mean, maybe. They might not want to mess with this shit, right? It might be a disaster. They might think your case is amazing and heads are going to roll, right? Ramona Hudson says, during the online mediation, are there breaks? What if I have to use the restroom? There are absolutely breaks, and you can ask to use the restroom anytime you want. 2 minutes. 2 minutes to go. Nico Gomez says, how many people usually works on your discrimination case? Nico, at our firm, you're going to have 3 attorneys and 1 non-attorney working on your discrimination case. Kelsey, my pleasure for answering your question. Happy to do it. Poetic instrument. I've contacted employment lawyers left and right, and no one wants to take my case. I submitted a formal complaint to my employer, a large public university. I have no idea what else to do. Poetic instrument. Have you hit up our How to Find an Employment Attorney playlist? It has a lot of information on how to like really pitch your case to attorneys so they might listen better and might, make you an offer of representation. Psalm 003 says, I recently informed my direct supervisor of detailed medical disability information in an email. She forwarded an email to another super who is triggering trauma and panic attacks and shared confidential information. Is this a HIPAA violation? The supervisor was already given a reasonable accommodation memo to keep information confidential. I mean, I don't know if that's a HIPAA violation because you just kind of sent your information out. And it's yours to share. I don't know off the top of my head, Sam. I apologize. Poetic instrument says, I am a tenured professor and cannot be fired from my position. Awesome. The EEOC and the Jobs Disability Network believe I have a case, but I can't find a lawyer. It's so unbelievable. Poetic instrument. If you can't find a lawyer locally, talk to the national firms, right? Gloria Allred, Shigarian, I think Morgan and Morgan, our firm, right? And I'm not vouching for any of these firms. I'm allowed to vouch for any firm, but I'm just saying, if you can't find representation locally, you can always broaden your search. Mohamed says, hey, Vince, my lawyer seems disinterested after our demand letter and settlement was declined. I have confidence and proof my termination was retaliation. I'm sorry to hear your lawyer seems disinterested. That's not good. Listen, if your lawyer's not doing it, start taking, free consultation with other lawyers locally. I Go Viral says, I was moonlighting and my company found out I was terminated. Oh, I was moonlighting and my company found out I was terminated, left peacefully. That day they told a customer I went mad. 2 days later, I called my employer to have me fired. Is this retaliation? No, probably. I mean, listen, is it retaliation like colloquially? Yes. Is it a retaliation claim? Not that I can see, but check with local counsel. Local laws can differ. Mohamed, should I find a different lawyer? If your attorney seems disinterested, certainly you might want to talk to different lawyers. Carol Moser says, hey, Vince, it's great to see you live. It's great to see you, Carol. Is it legal for an employer to fire you after you file a discrimination lawsuit? That is a retaliation claim. They handed you a retaliation claim. Okay, we are over. I see 2 questions left. I'm going to answer those last 2 questions. That's it. We have a question from Andra Rodriguez, and we have a question from Ra-Ra's Jewel69. Ra-Ra says, although I'm told I have a strong case, my lawyer is refusing to offer contingency. If we get the right to sue letter from the EEOC at the last minute, would another lawyer be more willing to take my case with contingency? Listen, a lot of firms do want that right to sue letter. It doesn't make a difference for us. We just would be happy to contact the EEOC and get the right to sue letter for you. But some firms like having the right to sue letter. It could make your case more appealing to some firms. Andra Rodriguez says, thank you for all you do, especially when you're not feeling well. My pleasure. Happy to help. Listen, I feel fine. I just have a cough. It is greatly appreciated. I have watched many of your videos in the past few weeks. I hope you feel better soon. Thank you so much. It's very kind of you. EMW says, I live in Maryland and I have a charge for discrimination. Can you represent me in New York? We represent workplace discrimination and workplace sexual harassment cases in all 50 states. EMW. I always tell people to check their local counsel options, although I have noticed that people out of Maryland have been complaining about local counsel options, but definitely check first. John Doe KCK, thanks as always, Vince. Have a great weekend. You too. You too. Jealous that you have fresh veggies and the best possible chickens. That's 100% clean and organic. It is better than organic, but thank you very much. I appreciate that. Jeremiah McKinnis says, I need you so we can get dirty with the people spreading the dirt. That's what I do, Jeremiah. That's who I am. Charles Johnstone, it's good to see you. I do like the farm. I don't like you calling my farm a plantation. That makes me deeply uncomfortable. I work on my farm and I pay the people who work on my farm. And I don't like it being called a plantation. Thank you for saying you're just kidding. All right, everybody. I hope you have a wonderful weekend. I was only going for an hour today because of the cough. Have a great weekend, everybody. Take care. Good things for all of you. I hope you all win your cases and all the good things happen. I will see you next week and I will keep the videos coming. Like, subscribe, comment down below. Take care, everybody.